A federal judge just did something almost no one saw coming. He did not remove one attorney. He did not flag a single conflict of interest and ask for a review. He wiped out Pam Bondi's entire DOJ litigation team in one sweeping, immediate, unreviewable court order. Every attorney gone. And then he gave the Trump administration exactly 72 hours to replace all of them or face consequences that reach far beyond anything the headlines are currently covering. I have read every page of the full 47-page ruling. What I found buried inside it is significantly more serious than what most people are reporting. So let's go through this the right way, starting with what the order actually says, not what the press releases want you to believe. Here is the baseline. Pam Bondi was appointed Attorney General by President Trump following confirmation battles earlier in his term. The attorneys she personally installed to run DOJ litigation, her handpicked team, just got thrown out of federal court. Not for sloppy paperwork, not for a minor technicality, for what the presiding judge, a Reagan appointee, called actual conflicts of interest. Not the appearance of conflicts, not the possibility of conflicts, actual ones. That is a substantially harder legal standard to meet, and this judge met it anyway in a ruling that left no room for interpretation. Here is the timeline. Weeks before Monday's order, defense attorneys in 3 separate federal cases began flagging potential conflicts involving members of Bondi's litigation team. Days later, formal motions for recusal review were filed with the court. Friday, an emergency closed-door hearing took place. And then Monday afternoon at 2:47 p.m. Eastern, the order dropped without any warning, posted directly to the docket. No advance notice to any party, no opportunity to prepare. The court hereby disqualifies all government counsel of record in the above captioned matters. That sentence covered 14 separate cases. $127 million in active litigation across 23 pending matters, all of it frozen in place immediately. The DOJ's communications office went completely silent for 4 hours following that moment. The White House press secretary faced 3 direct questions from reporters and dodged every single one. Bondi canceled her scheduled afternoon press availability entirely. Her formal response came 11 hours after the order dropped, 2 sentences. The department disagrees with this procedurally irregular ruling and will pursue all available remedies. That was it. That is not a legal defense. That is buying time while the clock runs out. Now let's get into what the order actually documents, because this is precisely where coverage of this story has been weakest. Page 12 of the ruling, lines 4 through 9. The government's lead counsel maintained an active partnership stake in Morrison & Keefe LLP while simultaneously directing litigation strategy against former clients of that firm. That is not my analysis. That is the language of the court filing itself. What it means in plain English, the attorney who was leading these federal prosecutions had an active, ongoing financial relationship with a law firm that was representing the opposing parties in those same cases, while the prosecutions were actively underway. But that alone is not what made this order possible. What made it truly devastating is what the judge found on page 31. He documents 7 specific instances where internal case strategy discussions occurred within 48 hours of financial payments flowing to that connected firm. Wire transfers $3.2 million in total across 19 months of overlapping activity. That is not a conflict. That is a documented pattern. And patterns like that are what federal judges issue disqualification orders over. The pattern has a clear timeline. November 2025, the first conflicted attorney joins the DOJ team. January 2026, a second attorney from the same firm network is added. March 2026, a third attorney joins, one who was the former managing partner of that same firm. All 3 are documented in the order. All 3 are now gone. Here is the part that almost no one reporting on this story has covered adequately. Page 38, footnote 14. The judge specifically notes that Bondi personally approved every one of these hires despite receiving 4 separate written advisories from the Office of Professional Responsibility inside the DOJ, her own career ethics office. 4 memos. Read what each one said. September 2025, the first memo specifically names the Morrison and Keefe connection by name, uses this phrase, recommend against appointment. November 2025, the second memo. Stronger language this time. Continued engagement risks judicial intervention. January 2026, the third memo. Formal objection lodged. February 2026, the fourth memo. We have exhausted internal remedies. That is the career ethics apparatus of the Department of Justice telling political leadership in writing 4 separate times over 5 consecutive months, do not make these hires. And every single time, Bondi's team moved forward anyway. Page 41 of the ruling addresses the implications of that sequence directly. The court states the government cannot claim surprise at this ruling when its own compliance apparatus provided repeated documented warnings. This was not a mistake born of carelessness. This was a deliberate decision made with full awareness of the risks. And the judge says so explicitly. Now let's talk about the real stakes inside those frozen cases, because this is where the story stops being abstract and starts affecting people directly. The 3 highest profile matters currently in limbo involve a major tech antitrust prosecution with $89 million on the line, a defense contractor fraud case naming 41 individual defendants, and a civil rights enforcement action that has been building through the courts for over 2 years. All 3 are now stayed pending replacement counsel. Within the 72-hour window, by Thursday, March 26th at 10:00 a.m., the Trump administration must submit replacement attorneys to the court. And the judge is explicit about what that means. These are not just any available attorneys. The order specifies no connection to the firms identified in this ruling, no prior representation of any party in these matters at any point, full financial disclosures submitted directly to the court prior to any appearance. Page 44 makes the expectations absolutely clear. The court will scrutinize any proposed replacement counsel with heightened attention to the conflicts that necessitated this order. Translation, he is personally reviewing every single name submitted. And page 47, the final paragraph before the order signature, the judge reserves ruling on whether to refer this matter for potential bar discipline. That is not a resolved question. That is a live threat. The professional consequences for these individuals could extend far beyond losing these specific cases. But simultaneous with all of this, and this is what the coverage is missing entirely, something else is happening on the same timeline. Thursday's hearing is not just about replacement attorneys. The docket entry reads, status conference regarding potential supplemental remedies. 2 words that are doing enormous work. Supplemental remedies means the judge is holding open the question of additional consequences beyond the disqualification itself. Monday evening, a sealed filing appeared in the docket from defense counsel in the tech antitrust case requesting sanctions for litigation conduct. The judge ordered a formal response due Wednesday at 5 p.m. That means Bondi's remaining non-conflicted DOJ staff now has 24 hours to respond to an active sanctions motion while simultaneously identifying qualified replacement counsel for 23 frozen federal matters. That scheduling is deliberate. The 72-hour deadline forces rapid action. The simultaneous sanctions briefing divides resources and attention. The Thursday public hearing creates a moment of accountability. The judge is not just disqualifying attorneys. He is controlling the pace and pressure of what comes next. The appeals court variable is the only open question that could change Thursday entirely. DOJ filed an emergency stay request Monday evening at 6 p.m. as of Tuesday morning, 18 hours of silence from the appellate bench. If a stay is granted before Thursday, the order pauses. Bondi's team potentially remains in place. Everything I just walked through becomes a temporary legal footnote. But if the appeals court stays silent or denies the request, Thursday morning becomes the single most consequential DOJ courtroom moment of this administration. And the legal experts who have reviewed this ruling, including those who are critics of this judge, cannot identify a comparable situation in recent federal legal history. Now, let's also be fair about where the counterarguments live, because they are real and they deserve to be addressed directly. DOJ defenders have raised legitimate points. Their position is that these conflict rules contain gray areas. The attorneys in question left their prior firms. Waiting periods were technically observed. The letter of the ethics rules was arguably followed throughout. A former assistant attorney general put it plainly, courts should be reluctant to disrupt ongoing federal litigation based on attenuated conflict theories. Even a legal ethics professor at Georgetown, not an ally of this administration, acknowledged the conflict standard applied in this order is stricter than some courts would require. And the timing of these motions raised by defense attorneys when two cases had trial dates within 60 days is strategically transparent. The judge acknowledged that on page 22. Then he said, the timing of the challenge does not diminish the validity of the underlying conflict. Yes, the defense played this strategically. That does not mean they were wrong. And 4 written internal warnings from the government's own ethics office makes it very difficult to argue inadvertence. The ripple effects are already spreading. Defense attorneys in other federal circuits are reading this order tonight. By April, legal observers expect similar motions to be filed in other jurisdictions. The standards this judge applied will be cited. Other judges will be asked to apply them. The 23 cases frozen right now are only the beginning of what this ruling could set in motion across the broader federal docket. 44 hours until the deadline. 1 federal judge, 4 ignored internal warnings, 340 pages of exhibits, 23 frozen cases, and a Thursday hearing with supplemental remedies still sitting on the table. The order dropped Monday without warning. What happens Thursday will either close this chapter or open a far more damaging one.